You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes.
Are you okay? Yes. You're getting white. She's getting white. More reading of the motion.
She will, Your Honor.
Give me just a second to get that flipped up.
Our agreement, Your Honor, is for her to be on special needs safety.
Thank you. Sorry, it's taking a minute for my computer to get pulled up here. Okay, so Ms. Willilifford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to count?
That up to 20 years line is the judge pulling the camera lens back to the real stakes. Because what's happening here is the court choosing rehabilitation, but only if the defendant respects the power of the situation. The judge is laying out the purpose of the special needs safety program. Help with substance abuse, help with mental health, help with stability. So when she gets out, she doesn't spiral back into violations. But the warning is crystal clear. If you don't follow through after getting that help, the court is done negotiating. And notice the tone. Listen carefully to what I'm saying. That's not casual. That's a judge telling you the next chapter of your life depends on whether you can obey simple rules. The court is basically saying, I'm not revoking you today, but I absolutely can. This is also where a lot of defendants break down, not because they don't understand, but because they suddenly do understand. And how you handle that fear matters. Some people get humble. Some people start bargaining. Some people start talking too much. And in court, that can backfire fast.
Counts 3, 4, 7, and 8 freely and voluntarily. And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Willilifford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I would get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Actually, went better than I thought it would, actually.
Really?
This is one of the times it's great to have on camera.
Oh.
She's never seen me. I'm literally biting my tongue.
You just never know.
Jesus is what?
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said friggin'.
Well,
You know what she meant. I know what she meant.
Kashma Thomas, Mr. Rojas.
I told him that's for a piece of paper. I told him to do it.
Just don't do it. I don't know why they don't listen. It took me about.
Market, and I transported for him. When I brought him there, let me back up. When they put him in my car, they strapped him in. This is the Detective Williams had put him in my car because I already had somebody else in my car too as well. I transported 2 people. I brought him there, and when I got him there, when he crossed the guard lines, one of the officers had found a BB gun tucked in his sack. Like tucked in between his legs, like it was in the front part of his waistline or something of that nature.
Okay, I'm a little confused. When you say a BB gun, describe to me what you're talking about.
A BB gun. So it wasn't an actual physical gun. It was a gun that shoots pellets. So it was a black. It was like a black hand. It looked like.
That's all, folks.
All right, this hearing is not about a brand new crime. This is about what happens when you're already on deferred probation for a second-degree felony aggravated assault with a deadly weapon, and then you start stacking violations like they don't matter. The court is looking at a motion to revoke, and the defendant, Miss Willilifford, is agreeing to plead true to multiple counts, including THC positives, not completing anger management, and being behind on fees. That's a dangerous mix, because probation is basically the court's trust in written form. And once the court thinks you're ignoring the conditions, that trust disappears fast. But here's the hook. Instead of immediately revoking, The state and probation are pushing a special needs safety program option, meaning they're trying to salvage probation with treatment, structure, supervision, and accountability. That sounds merciful until you realize what the judge is really saying. This is the last rope. The judge is already warning there will be no third chance, and the punishment range for the underlying charge is massive, up to 20 years. So every word matters, every attitude shift matters, and every excuse is going to get tested. Watch closely for two things. 1. How the judge explains, I could revoke you, but I'm not today. And 2. How the defendant handles pressure, because in a courtroom, panic can turn into self-sabotage in seconds.